Meaningless formality? No. Freedom decided in minutes.
Your first court appearance could determine whether you spend tonight at home or in a jail cell. Hi, I'm Darryll Stallworth, and today I'm explaining criminal arraignments, that critical first step that many people completely misunderstand until it's too late. If you've been arrested or received a notice to appear in court, you're about to face an arraignment. And let me tell you, this isn't just some meaningless formality. It's where your fundamental rights are explained, where decisions about your freedom are made, and where the entire foundation of your case is established. Today, I'll walk you through exactly what happens during this hearing, what decisions you'll need to make on the spot, and why having an experienced attorney by your side from this very first appearance can completely change how your case unfolds. So what exactly is an arraignment? It's your first official appearance before a judge after being charged with a crime. Whether you're facing a misdemeanor or a serious felony, California law requires this initial hearing to kick off your case. During these first minutes in court, several things happen in rapid succession. You hear the formal charges against you. The judge explains your constitutional rights. You enter your initial plea. Bail decisions are made, and future court dates get set. Think of the arraignment as the starting line of your criminal case. And just like in any race, how you start can determine everything that follows. The timing of your arraignment depends on your situation and the charges you're facing. If you're sitting in jail after an arrest, your arraignment must happen within 48 hours, not counting weekends and holidays. That's why so many arraignments happen on Mondays for weekend arrests. If you're free because you posted bail or were released with a citation, your arraignment might be scheduled several weeks out. For felony cases, you'll typically go through two arraignments, an initial one right after arrest and a second one after your preliminary hearing if your case moves toward trial. For misdemeanors, you'll have just one arraignment, and in some cases, your attorney might even be able to appear for you so you don't have to miss work. During your arraignment, the judge will run through several constitutional rights that protect you throughout the criminal process. You have the right to an attorney, and if you can't afford one, the court must appoint one for you. This is why you should never hesitate to request counsel immediately. You have the right to a speedy trial. In California, that means trial within 30, 45 days for misdemeanors or 60 days for felonies, unless you choose to waive this right. You have the right to confront witnesses against you, the right against self-incrimination, and the right to a jury trial where 12 community members decide your fate. Understanding these rights is absolutely crucial because decisions about them will be made incredibly quickly during your arraignment, sometimes in just minutes. The most pivotal moment in your arraignment comes when the judge asks for your plea. You have three options, and this choice matters more than most people realize. A not guilty plea denies the charges and forces the prosecution to prove their case. This is almost always the smartest choice at arraignment, even if you might consider a plea deal later. It keeps all your options open and gives your attorney time to investigate, review evidence, and negotiate from a position of strength. A guilty plea admits to everything you're charged with. I cannot tell you how many times I've seen people make the devastating mistake of pleading guilty at arraignment just to get it over with, not understanding the lasting consequences this will have on their lives. A no contest plea functions basically like a guilty plea in criminal court, but can't be used against you in civil lawsuits related to the same incident. Another critical aspect of your arraignment is determining whether you'll walk out the courtroom door or be taken back to a cell. Bail and release decisions are made at arraignment. The judge can release you on your own recognizance, which is essentially your promise to return for court without paying any bail. They can set bail, which is a financial guarantee that you'll return for future hearings. The amount depends on your charges, criminal history, community ties, and flight risk. They can also impose specific conditions on your release, things like stay-away orders, travel restrictions, or electronic monitoring. In serious cases, or if you're considered dangerous, they might deny bail completely. California has been moving toward more individualized assessments of release decisions rather than just following standard bail schedules. This makes having an attorney who can effectively argue for your release or reduction in bail even more crucial. Next, we'll talk about what happens after arraignment. After your arraignment, your case will branch in one of several directions. For misdemeanors where you've pleaded not guilty, the court will typically schedule a pretrial conference and possibly set a trial date. For felonies, the court will set a preliminary hearing date, which must happen within 10 court days if you're in custody or 60 days if you're not, unless you waive these timeframes. If you've pleaded guilty or no contest, the judge might sentence you immediately for minor offenses or set a future sentencing date for more serious charges. The arraignment also starts the clock on discovery, when the prosecution must share their evidence with your defense team, and it establishes the formal relationship with your attorney, who can immediately begin building your defense. Having an experienced defense attorney at your arraignment can completely change the trajectory of your case. We'll review the charging document for legal insufficiencies that might lead to dismissal or reduced charges. We know how to make compelling arguments for your release that address the specific concerns of judges when assessing release criteria. We understand and can explain when preserving your speedy trial rights helps you and when waiving them might actually benefit your defense. We can begin negotiating with prosecutors immediately, sometimes resolving minor cases right there at arraignment. We can spot issues with your arrest or evidence collection that could form the basis for future motions. And most importantly, we can provide clarity and guidance during what's often a confusing and overwhelming process, ensuring you don't make split-second decisions that you'll regret for years to come. At our firm, we've stood beside countless clients during that critical first court appearance, and we've seen firsthand how having skilled representation from day one can completely transform the outcome of a case. Our team brings years of experience to arraignments. We know how to advocate for your release, preserve your rights, and begin building your defense strategy from the very beginning. If you or someone you care about is facing criminal charges, don't wait until after arraignment to get help. Reach out today to schedule a consultation with a legal team that knows how to prepare, protect, and advocate for you from the very first court date. If this video gave you some clarity on what to expect, go ahead and hit that like button. Subscribe to our channel for straightforward legal guidance. And tap the bell so you're always the first to know when we release new content. When it comes to criminal defense, knowing your rights isn't just smart, it's your first line of defense. Thanks for watching.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.